You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Session. All we have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good Good morning and welcome to the Florida Supreme Court. We have three cases on our docket today that are related. The first case is Hernandez versus the state of Florida.
Good morning. May it please the Court. Michael Bastien for Petitioner Gabriel Hernandez, also with co-counsel Sui Chung at the table. Petitioner in this case received ineffective assistance of counsel in violation of his Sixth Amendment rights.
Before we get to the substance of your argument, your case hinges on Padilla being retroactive, correct?
Yes, it does.
Because this is was a 2001 guilty plea.
Yes, it was.
And just a point, and maybe the record shows it or not, since he had that guilty plea, he received his BA and he's employed as a computer network administrator.
Yes, he is.
So at this point, he hasn't been deported.
Right.
But it's what you say it's mandatory.
Yes, it is, Judge.
Have they started proceedings?
I can explore this, I think, answer a lot of these questions.
Okay, maybe you could, because what my concern is about as we get into a post-Padilla world, and yours may not fit in there, is that he was facing 15 years in prison, correct?
Yes.
And he got a plea to what?
Probation.
Probation. So if the lawyer were to say, you will be deported if you plead, but if you don't plead and you're guilty, you could be spending the next 15 years in prison. So wouldn't part of the duty of trial counsel always be, because we're talking about people that may in fact be guilty or may not, but that here's the risk. The risk is you go to trial and you'll get 15 years. So if in this situation, if his lawyer said, listen, if you plead to this, you are subject to presumptively mandatory deportation. I can't tell you whether it will happen or when it will happen. But on the other hand, if you don't plead and you go to trial, you're subject to 15 years. So is that what you would say if we were, again, rolling back the clock, going forward, that lawyer would have to both talk about the consequences of going to trial and what the maximum sentence is versus the reality of the deportation?
Okay. Yes, Judge. I think this, the issue is, it goes to the reasonableness of whether he whether it would be reasonable for him to have rejected the plea. And this case arose without the benefit of an evidentiary hearing to explore that. But I think what you're getting at is, what is the counsel's role? And the counsel is in the best position to evaluate all of the factors that. I'm sorry.
No, that's okay. Go ahead. Finish it. I'll catch up with you later.
But we argue that counsel is in the best factor to provide these advisals. That they're in the proper position to evaluate all of the motivating factors for the defendant, as well as to evaluate the case against them. And of course, the state offered this plea at an initial sounding hearing. There's nothing in the record. Yes, there was a maximum possible sentence, 15 years, but there's nothing in the record to show that that was actually what would have been a likely outcome for this case, given the de minimis amount that was involved in it, and many other factors that, again, would go to more to the reasonableness of whether he would have rejected the plea.
Can INS, let's say that he goes, and I used to do a lot of these cases. I used to represent a lot of criminal defendants who have immigration problems. So I've been down this area before. Now, let's say that he chooses to go to trial and he's acquitted of the criminal charges. My understanding is that the immigration department can still pursue a deportation because they have a different standard. It's not reasonable doubt like in a criminal case. Is that correct?
I can be very specific about that. It's an unusual circumstance. If that is, again, outside of this, but to take your question directly, A person that is charged that the Department of Homeland Security has a quote reason to believe has committed a drug trafficking offense can be charged with being inadmissible to the country. If they travel abroad and are returning to the country, then they are subjected to that standard that, yes, is below the reasonable doubt standard. However, then that becomes the subject of a hearing regarding the reasonableness, and having prevailed at trial would be highly the ultimate facts of the case would have been resolved, and again, proceeding with conjecture.
You're saying that's not a ground for deportation?
No, that would arise in a different context, and I would think if this was litigated in a criminal context and he was found innocent, the DHS would be extraordinarily unlikely to prevail at trial in the immigration court context.
So we're at a stage here, if we accept that counsel in this case was ineffective because he did not, in Mr. Hernandez's case, tell him about the immigration consequences. My question then is, what is the prejudice prong of this case? You've got deficiency, but what is the real prejudice here?
Mr. Hernandez is barred from any sort. He is deportable because this offense is considered an aggravated felony, which is post-1996 is the worst type of categorization under the Immigration Nationality Act.
And it's been 11 years now. Has he been subject to anything from INS?
He has not to this time. But again, the Supreme Court, this is convenient because this is the same issue that arose in Padilla, because it's the same deportation ground as an aggravated felony, and they ruled that it was a clear and mandatory legal consequence.
But they remanded the case so that a prejudice determination could be made. So what would be the prejudice that could be demonstrated in this particular case, other than he may not have pled guilty?
Okay. Because this is an aggravated felony, he is barred from there's generally two forms of discretionary relief that a deportable person may consider if they are eligible for an immigration court. He is barred from both of those because this crime is considered an aggravated felony. Therefore, at the time that he entered this guilty plea, the guilty plea combined with the immigration law, he became mandatorily deportable. This action has not happened yet, but he is.
Had one of those forms been filled out to determine what would have been the allowable sentence if he was convicted of this crime? You know the form you fill out and you go through all the numbers and figure out what is the sentencing range for a particular defendant? Had that been done in this case? So do we have any idea of what sentence he would have gotten or been subject to had he gone to trial?
Okay. I am not aware of that. I don't want to over-represent, but again, that would go to the issue of reasonableness, of course. If the score sheet was low, that would be a factor that would show that it would be more reasonable to decline to accept the plea.
Well, did he allege in his motion that this was a plea of, and Justice Labarge would know the term better, of convenience? In other words, that he wasn't guilty of selling LSD to a undercover agent, but that he was told by his attorney, you can get on with your life by this probation. He was 19 at the time. Does he have to, in other words, he has to allege for setting aside the plea and the prejudice prong of Strickland something more than he pled guilty. He would have to say either I wouldn't have pled guilty, but then don't we have to also show that there would be a reasonable chance that he would have been convicted of either a lesser offense or acquitted?
Well, he does allege that he would have, regarding the first primary question, he does state in his sworn motion that he would have pursued any and all other defenses available to him.
I was struck in Padilla that Justice Stevens really talked about the fact that if a competent counsel knows about this being a mandatory deportable offense, that they could negotiate a plea to another lesser included offense that would not be a mandatorily deportable offense. So that would be part of the prejudice problem, correct?
Yes.
Now, one other thing before we get into retroactivity, which I think is your big hurdle here, I have struggled because I've been on this court and I had Boulware and Major and all those cases that we have seemed to tie what is a proper plea colloquy for what a trial judge has to do with what competent counsel has to do. And there's no, as I've read all of these cases that have come up, there's no attack at this point on the court's colloquy, which is you may be deported, because it's a generic one-size-fits-all, and nobody's suggesting that trial judges should be schooled in the nuances of which are mandatorily deportable offenses. Is that correct, first of all, that you're not attacking the trial judge's colloquy?
Right. What we believe is, as a result of this case, the court will see that the colloquy has, no utility as far as curing ineffective assistance of counsel, and perhaps limited utility in general.
Well, do you
on this
see
issue.
then that if we were to, going forward, that we would have to recede from several of our cases where we have tied what is a proper colloquy, direct collateral offenses for a trial judge, untie it from what would constitute effective assistance of counsel? In other words, that there's a greater duty on the part of counsel in these, serious consequences, because I think the Supreme Court has said we're not talking about direct collateral, that we have to explicitly say that those two duties are different.
Yes, and I think they are distinct.
Have you seen which cases we'd have to recede from in order to make that statement?
I'm sorry, could you rephrase that?
What cases from this court over the last 20 years we would have to recede from in order to make that statement? Because today it's deportable offenses, tomorrow it is sex offender registration, the next day it's driver's license revocation, all those cases that we have found to be serious but not direct consequences. None of those talk in terms of a separate duty on the part of the trial lawyer from the trial judge.
Right. I think but it's important that this responsibility properly lies with the attorney. I think the judge can provide a safeguard that these discussions have taken place. But ultimately, the Sixth Amendment right to counsel is the right to effective counsel, and these issues, to the extent that each that you enumerate is a constitutionally protected right, as Padilla solved this one, so we know that this is something that must be covered.
Well, why couldn't you? Now let's go back to the Padilla issue. Mr. Padilla brought his challenge within 2 years of his conviction. Your client pled guilty in 2001, 11 years ago. Why should we, this court, why should we not wait till the U.S. Supreme Court decides the issue? Or, second of all, say that there was nothing preventing your client from raising a separate ineffective assistance of counsel claim within 2 years on this precise issue, when at some point when your client, who is presumably an intelligent person, realized that he had pled guilty to a mandatorily deportable crime.
Right.
To say, wait a second, I had a public defender that told me none of this, and in a 10-minute session, the judge said may, and I figured, well, I'm okay with may, but if I had known shall. You're not telling us that he couldn't have figured that out in the 2 years after his plea was entered.
Okay. Well, again, I don't want to talk too far out of the record, but you're right. As an intelligent person, any defendant would weigh their options. But his claim was previously barred by Ginebra, which was directly on point, and therefore he would have known and did know, in fact, that any claim, if he brought it, would have been met with summary denial by the courts. This has, and related issues such as the Peart and then the Green case. Those cases came and went, but none of them were applicable because with Ginebra over him, his claim could not be brought previously. I'm sorry.
Let me just ask you a procedural question as to how it is that the case is here. My understanding of what you're saying is that the Immigration Department did not seek to deport. He has not been placed on notice that he's going to be deported because of what happened 11 years ago. Am I correct?
Correct.
So your client basically is doing a preemptive strike here. He's trying to pretty much undo, vacate the plea, start over again. Correct?
Yes, but what we've learned from Green is that this court has acknowledged that immigration consequences are certain whether or not the proceedings or the actual removal has started being affected.
Well, I understand that, but you see, your client waited so long in which to start this process because I think I'm concerning also the prejudice to the state. I mean, if his plea is vacated, I just don't see how that could have been proceeded. I mean, the drugs are gone, the agents are gone. Everybody's gone. How is the state going to prove its case? Should they decide to refile it and continue with the prosecution? See, there's a big prejudice there as well.
There is, but I think it's two-sided. A concern that we had with the decision below was that it really did stress the prosecutorial concerns of the state without the equally, if not exceedingly, countervailing interest of the petitioner. We argue that the courts as a neutral party would have no interest in maintaining a conviction that, by all accounts, seems that it was likely achieved through a violation of the Sixth Amendment right to effective counsel. And so, yes, there are balancing concerns, but again, going back, it ties in with the issue of reasonableness. Because we don't know how this case would have played out at trial. The state was quite quick to not pursue a 15-year sentence and take what they could get at the initial sounding hearing.
But this goes back to the retroactivity, and I have shared Justice Labarga's concern, which is that Witt says, and we're following Witt, that this plea colloquy has existed for over 22 years, and we have, I don't know what the numbers are, maybe someone needs to bring that up, but there's nothing under your scenario. This was 2001, but this could have been 30 years ago. And I have some great concern. I mean, I feel for your client. I understand the realities, and maybe the state in cases where the crime is really relatively weak, they may make a decision to allow you to vacate the plea just by the way people do things, some concern that he's with a bank and he's gainfully employed, and it would be a tragedy. But we're here to really look at what the effect would be on the administration of justice. Do we know how many cases would be, do we have any numbers of how many cases would be subject to motions for post-conviction relief? You've got lawyers that are no longer, won't remember or are not alive. We've got state evidence that's lost. Do we know if it's 10, 20, 100, 1,000, 5,000?
I think it's difficult to speculate. What we do know is how many cases have arisen so far. In one of the briefs, we cited the numbers that we could see that had gotten to the third DCA, which at the time we filed the brief was about 55 cases have been
you would
removed.
assume that the reality is a good number of them, the majority would be in probably the 3rd District and the 4th District?
Because of numbers and demographics, I suppose. And so it was, I think...
Well, is that a relevant concern? In other words, do we do that in a Witt analysis? Do we look at how many convictions we're talking about?
It is a concern as a factual matter, but the floodgates issue was, it was discussed at length in Justice Stevens'
But that wasn't as to retroactivity. We have a different issue for retroactivity.
But what Stevens said was, we don't expect this decision will bring about a flood of cases that have already been resolved. because we will presume that because these professional norms have been in place for so long that most counsel should have known and should have advised.
Well, that is where the reality of the U.S. Supreme Court and the reality of what goes on in the public defender's office in Miami are worlds apart. Correct?
That's true, and it's largely a product of Geneva. They didn't have to be proactive, and it's unfortunate. But then when we apply this to the Witt test, it puts us in a difficult argument, which is so much, assuming there is a large number of cases, which I'm not willing to concede that this is an overwhelming number of cases, but assuming there's a large number of cases, that is because the Florida courts, unfortunately, got Geneva wrong as revealed by Padilla. And so if there is a large, the issue becomes so many people have been harmed that we can't help any of them. The violation was so great that we must ignore it because of efficiency concerns, which I don't think is the proper way to proceed, because under Witt we must consider what was the impact we have to be concerned with fundamentally fair criminal proceedings as part of the administration of justice. If there's a question as the accuracy, the reliability, the fairness of the proceedings, and the actions of counsel that undermine the confidence in those proceedings is hugely problematic.
You have exhausted your time.
Thank you.
May it please the Court, my name is Chris Davenport and I represent the state of Florida. First of all, let me say that this Court could eliminate this Padilla problem completely by holding as a matter of law you cannot demonstrate prejudice as long as the plea colloquy was followed as required by this Court 20 years ago.
Could you clarify something? I've read Padilla. That came from Kentucky, Tennessee, Kentucky. Apparently, they have a plea colloquy in that state. Does the record, either the lower court or the Supreme Court record, show what the colloquy was that Padilla was given at the time he entered his plea?
The Kentucky courts have a colloquy now. It looks from footnote 15 in the Padilla opinion. They cite that Kentucky currently covers this in its plea colloquy. They cite a 2003 form. Mr. Padilla pled before that. When you look at the lower court opinions out of Kentucky and the oral argument from Padilla itself, excuse me, there's never any mention of a court covering this at all. So the only thing we can glean from that is that Mr. Padilla was not given that information from the court.
Yeah. The problem I have with that is that we have this one-size-fits-all, and you cannot expect a trial judge. They ask it whether somebody's a citizen or not a citizen. We don't have the trial judge having to say, well, let me ask you this, where were you born? So it's a cookie-cutter colloquy, and it's adequate. But it says that you may be subject to deportation. Is this case seems, other than the issue of the retroactivity, which I'm sure you'll address, to be precisely the same problem, which is that this is a presumptively mandatory deportation offense. Does the state dispute that or agree with that?
I would agree that if deportation proceedings are initiated, then it would be mandatory deportation.
Okay, but we have already said in green that we're not going to say somebody can wait it out for 30 or 40 years. Apparently grandparents are deported. I mean, until the United States gets around to deporting somebody, we say it starts from the day in green, the day of the plea. So the issue is, it would be wrong to say you will be deported within the next year. I mean, we can't say that. But the issue is you have the risk that the United States will go against you, but it's certain that if they go against you, you will be subject to mandatory deportation. That's not what the trial judge should say, but that's really what Padilla is explaining, that trial lawyers need to either get themselves knowledgeable about the certainty and the clarity of which offenses are deportable, and advise clients appropriately. So I have a problem, I guess, in saying that in all cases that you may be deported, which is what this court is, the colloquy currently, is going to obviate an ineffective assistance of counsel claim. And could you explain why that would be, that the counsel's duty isn't greater, knowing their client, having to counsel them on if this is a good plea deal, than what a trial judge is going to be doing in each and every case?
Well, you know, obviously the trial court's colloquy is going to be more generic than advice of counsel, but the trial court's statement to the defendant is also coming from the court, so it's not something to be taken real lightly. And I would submit that that's an accurate reflection of every situation, because Mr. Hernandez is here 10 years later. If trial counsel had said, you will be deported if you take this plea, he could have come back and said, you know, I got offered probation for a pretty serious crime.
But now I think you're wanting to rewrite Padilla, because Padilla, they could have said that Kentucky colloquy would now be adequate, but they go at great lengths to talk about trial counsel's obligation. And so I don't, you know, I just don't think that we can say that it may be a prejudice issue, which is what Justice Quince was asking about, which is that the trial judge is told the defendant, you may be subject to deportation. You're in this country and you're not an American citizen. That's it should be raise a red flag. Hold it a second. What do you mean I may be subject to deportation? Explain it to me, trial lawyer, trial judge. So it may be that an intelligent person is going to know enough there to stop the proceedings and say, I didn't realize that. But that goes to the prejudice, whether they would have pled anyway, not as to the deficiency.
It does, but ineffective assistance of counsel, for that to be a valid claim, is a two-pronged test. It's not just deficiency.
But we didn't have an evidentiary hearing here.
But prejudice, on the face of this record, prejudice is refuted, because the defendant can't possibly show that but for counsel's silence, I would not have taken this plea, when he specifically acknowledged under oath to the trial court that I face the risk of deportation and I understand that. That's accurate information from the trial court, and that's why the cases in Florida, assuming the rule is properly followed, the cases in Florida are different from Padilla. Mr. Padilla wasn't told anything by the court. The only information Mr. Padilla had was his trial counsel, who said, don't worry about deportation, you've been here long enough, not going to happen. And that's inaccurate.
That seems to me that would be a good argument if the Supreme Court seems to have taken pains to say two things, that generic kind of thing that we have in our plea colloquy would be fine under some circumstances, but if it's plain from the face of the immigration law that deportation would be mandatory, the court seems to say that you need to do more than what is done in our plea colloquy. And so that's the dilemma, I think, that at least I'm facing. Well,
the court, there is certainly language in Padilla that you could interpret it, if you take it to the extreme, that we need immigration lawyers on staff in the public defender's office.
Well, let me ask this question. I mean, it doesn't seem as though you can interpret it to the extreme. It seems to me that just a fair reading of Padilla, it's not an interpretation or extreme, but it's saying that if you fall within this category of mandatory deportation, that it's not enough. And that's not an interpretation or a stretch or an extreme. It's the state's position that Padilla does not say that?
It's the state's position that Padilla is a little bit all over the board. But Padilla's actual holding, when you look at we hold, that defendants must be informed of the risk of deportation. Florida is out front in that. We've been warning them about the risk of deportation for 20 years. Kentucky did not.
Did the Supreme Court or the opinion there indicate a difference between mandatory and those that were not?
It did. And,
I mean, is that not really part of this Padilla decision? Well, that's what I think creates the real dilemma. That, I mean, certainly that broad generic may could apply to everything.
But may is the most accurate advice you could possibly give. Again,
well, that's
if counsel...
what it seems to me that the Supreme Court's saying it's not. That's what's brought us to this day, that it's not sufficient. So the state disagrees with that reading of Padilla.
The state submits that reading is taking some of the more extreme language in Padilla and exploding it to every case.
But it seems to me when you read the concurring opinion in Padilla, that the concurring judges are saying that that's exactly what the majority is saying, that if it falls under that mandatory requirements, that you've got to take that step and tell them that. But if it's not so clear, then the generic kind of language will suffice. But certainly the concurring justices say that's what the majority opinion is saying.
The concurring justices, Justice Alito's opinion does allude to that. And when you read Justice Stevens' response to that in the majority decision, he said, we understand immigration law is complicated, and we're not saying you have to become an expert in it. But when it's obvious and it's inevitable, when it's plain.
When it's plain that this would be a mandatory deportation consequence.
Right.
Then you've got to tell them that. I don't see how you get around that language.
I mean, here it is. I mean, again, and I appreciate, and I think that it's important for everybody to understand when this court is charged with interpreting a United States Supreme Court opinion, we can't go and make a decision that it says something differently than it says. And I read it and I read it over, and first, it says that in the instant case, the terms of the relevant immigration statute are succinct, clear, and explicit in defining the removal consequences of Padilla's conviction. That's it. I mean, I don't have to ask you if it's said. It's said. And then they go on and say that, let me just make sure. Well, why don't you, because I found the other part where it says that it may be that in some cases it's not as clear, but in this case it's specifically clear.
It is, because it's a drug offense, right?
It says
yes,
that?
it does say that.
So that's what Justice Lewis was asking you about, that we're not, in this case, we're talking about a mandatorily deportable offense.
Right.
I was frankly surprised to learn that something like this would be that there's no discretion on the part of the INS when they decide to institute it. So it's like the sword of Damocles hanging over Mr. Hernandez's head for the rest of his life, correct? At any moment,
they decide to, yes.
He took made a decision to become so public that INS must know now that he's there and he may be the next to go.
That's certainly possible. It's also possible that he'll live out the rest of his life in this country with no problems at all.
And why would that be? Why would that be? In other words,
Because it requires...
you mean he should rely on the fact that the United States of America will not enforce their immigration laws?
Not that they won't enforce them, but that they can't enforce them against everybody. So by definition,
how many
some people will be.
I'm not sure I understand this. I know we have a lot of illegal immigrants in this country, but I thought this is a legal immigrant who now has a BA and has employment, and that there is no... do we have millions of these people that have been convicted of mandatory drug offenses that are just going to live the rest of their life and never be deported?
Well, Your Honor, the fact that he's here 10 years later illustrates that this is not a sure thing. I wouldn't bet any money that he's going to be deported. I wouldn't bet any money that he won't be.
Well, if you were the lawyer, let me ask you this, Ms. Davenport. If you were the lawyer for Mr. Hernandez at the age of 19, who had sold LSD to an undercover officer, and you knew that the offense that you were going to have your client plead to resulted in mandatory deportation, and you knew, as apparently they asked the lawyer for the state in oral argument in Padilla, that if he were to be deported to his native country, that he faced a likelihood of being killed would you think that by saying, you might be deported, that you would have fulfilled your obligations as a lawyer to this client to say, I got you a great plea deal, you're not going to serve time in prison, but you have to know that for the rest of your life, you will never know when the INS is coming to get you, and if they come and get you, I know and you know that you will face some severe problems in your home country. Is there any of that that is should be part of the discussion? And that's what Padilla seems to say, that defense lawyers, not trial judges, but defense lawyers cannot escape that responsibility.
Right. That's what Padilla says. And let me say, the state's not advocating that you try and overrule Padilla. Of course, you're bound by that. I mean, we understand that. My point is, there's language going both ways in there. Justice Stevens acknowledges that immigration law is not clear-cut in all situations. And from a realistic standpoint, Mr. Padilla was in a very different situation from Mr. Hernandez. And when they reviewed that case, they took it in the context of the only thing that he was told was, don't worry about it. That's the only information we had, and that was improper.
I did find the part. It's at footnote, not footnote, headnote 6. It says, when the deportation consequence is truly clear, as it was in this case, which is this, the duty to give correct advice is equally clear.
Right. I would quote, we now hold that counsel must inform her client whether his plea carries a risk of deportation. And I would submit that Florida's been out front in that and has been telling these people about this risk. If this was the reason they plea, if but for this issue I would not have entered the plea, then he had an obligation to stand up and say, risk of deportation, what are you talking about here? And then we could send him back to his counsel and they could explore that further. But for that silence from counsel, I would not have entered the plea. We would submit that the plea colloquy eliminates and refutes prejudice, and we don't need a hearing in this case. Now let me quote from footnote 15, the only mention we have of states that have this plea colloquy. Kentucky didn't have it at the time Mr. Padilla entered his plea, from everything we can find. They have it now. They had it shortly after he entered his plea. But in footnote 15, the Supreme Court cites the Florida rule that requires trial courts to tell the defendants about this risk. And they say, this isn't that big a deal. Many states require trial courts to advise defendants of possible immigration consequences. They didn't say, but they don't go far enough and counsel needs to go further. They said, we already have this in a lot of states. This floodgate argument is not the problem that the state had asserted in there.
It seems to me your argument would be a good one because Padilla was given basically misadvice.
Yes,
and the
that was it.
Supreme Court could have gone off on that and said, because he was given misadvice, he might be entitled. He's entitled to relief. But the court didn't do that. They actually said that he had to be given some affirmative information by his trial counsel.
He has to be given affirmative information by his trial counsel. In Florida...
And so what in this case was the affirmative information by trial counsel?
Well, if you believe trial counsel's email, he said, I told him about a risk. But, you of course have to assume that the allegations in the 3850 are true. His allegations are, they didn't tell me anything at all. No misadvice, we didn't mention it. But we have a plea colloquy that says he knew about the risk of deportation. He didn't apparently know the details. But, he's under oath in an important proceeding. He's waiving 100 constitutional rights. The trial court says, do you understand that this can be used against you in deportation? If this is news to him and but for that lack of information he wouldn't have pled, he has an obligation to not just say, yes, Your Honor, I understand that, and then 10 years later said, wait a minute, I don't.
I know you're spending a lot of time on the merits, but don't you want to talk about retroactivity?
I would like to talk about retroactivity because...
Let me ask you a question about retroactivity. U.S. Supreme Court's taken cert, and they're going to decide this soon.
Yes.
Is there something unique about this case that will somehow help that court on the issue of retroactivity, or should we just wait till they're ruled?
Well, this court certainly could wait. Now, the analysis in Florida is different.
You said it should or should not wait?
I would submit that you can hold now that it's not retroactive and stop this floodgate in the district courts. I mean, this is getting to be, there are, dozens of briefs coming up on this. This court could put a stop to it rather than waiting, or, you could see what the U.S. Supreme Court does under Teague. Now, this court is going to analyze it under the different standard of wit. So in that sense, not to take the other side here, but you could find it retroactive, and the U.S. Supreme Court could say it's not retroactive under Teague, but it could be retroactive under Witt. Now, I don't think you should do that. I think that would be a big mistake, and I think that this case clearly falls under the non-retroactivity under the Witt test. This court has already addressed a similar situation in Green. We used to require them to wait to bring these claims, and in Green, excuse me, this court said that that is really unworkable. We can't have these stale immigration cases coming up 10, 15 years later. We don't have plea colloquies anymore. Nobody's going to remember this. The state's at a huge disadvantage because they can't retry this guy anymore. In Green, this court recognized that stale immigration deportation claims is going to be very burdensome on the courts and is just not a good policy. All of the factors in Witt weigh against a finding of retroactivity. This is a classic example of an evolutionary refinement. It's not a dramatic, all of a sudden you have a right to counsel that you didn't have before. It refines the duties of counsel in this context. Again, Florida was ahead of this and was already telling these guys something. Whether that was sufficient or not is certainly debatable here today, but it is an evolutionary refinement, and we can't have this. These stale claims would overwhelm the courts. So we would submit it's not retroactive, which, excuse me, would of course bar Mr. Hernandez's claim because it was 10 years ago. Thank you.
We thank you. We thank you both for your argument. The next case on our docket is Diaz versus the State of Florida.
Morning. May it please the court, Benjamin Waxman of the Miami firm Robbins, Tunke, Ross, Amzell, Raven, and Waxman, and Ms. Arias from the Miami firm Pozo, Goldstein, and Miranda on behalf of Mr. Diaz. The retroactivity question asks this court whether it is going to hold Mr. Diaz and other post-conviction non-citizen defendants to their involuntary and invalid pleas. On the wall outside the lawyer's lounge, there's a quote from Justice Terrell, one of the great justices from this court, who said in one of his opinions that it is better to eat crow than to perpetuate error. And that really answers the question before this court. And the court said it in the exact same way in Witt. It recognized that there is some importance to finality in criminal conviction adjudications, but those interests have to give way when a process that's no longer acceptable and is no longer applicable to indistinguishable cases deprives people of their life and their liberty. And that's precisely what would happen if this court did not afford the relief to these defendants whose pleas are involuntary and invalid, but yet provide that relief to all defendants going forward.
But let me ask you this. You're now making a statement that the plea was involuntary. Are you suggesting going forward that the court standard colloquy needs to be changed? Do we need to change that colloquy in light of Padilla?
No, and I don't think the court has to recede.
But voluntariness and what makes a plea voluntary is the trial judge has an obligation, and we're in a unique situation because clearly going forward we have to recede from Ginebra. There's no question about that. The Padilla requires that. Do you agree with that?
Padilla abrogated Ginebra.
Right. Well, we'd have to recede from it. But let's go over the wit factors that we consider. And I think that the one that concerns me is that it meets the first two requirements, the extent of reliance on the old rule and the effect of the administration of justice of a retroactive application of the new rule. Are those two of the factors? And could you address the extent of the reliance on the old rule?
Well, the way I see it is the old rule is really Edwards, which was the case out of the 3rd DCA in 1981 that recognized precisely the very Sixth Amendment rights that are recognized in Padilla. And that, in fact, was the law in Florida from 1981 to 1987. Then this court decided Ginebra, and it's now clear that that decision was erroneous. It did not afford the full scope of counsel that Padilla makes clear exists. And so I think it's a little bit of a strange situation because we did have the law correct, and therefore that factor in terms of all the factors is not as significant as the others. In terms of
are you telling me that a 25-year period of time is not a significant time in the criminal law?
I'm saying that what I'm saying is that Witt identifies three factors. One, the court has to look at the importance or the purpose of the rule that's at hand, the purpose of Padilla. One factor is the extent of the reliance, and the third is the effect on the administration of justice. And what I'm suggesting is in this particular context, that middle factor is perhaps not as important as the first factor and the third factor. And the third factor, the effect on the administration of justice, was directly addressed by Padilla, where the court said it should have a very modest effect on the administration of justice because, again, these rules that required defense counsel to provide this very advice to their non-citizen defendants has been in existence for at least 15 years. And in fact, some of the law review articles, some of the standards that were cited both in Padilla and St. Cyr went back to the 80s. And there were cases from the 1980s that said defense counsel indeed has an obligation.
So here, couldn't you go back to as far as the 80s, and certainly from the time that 3.172 started including that generic information about deportation? Couldn't those defendants now bring 3.850 challenges to the effectiveness of their attorney?
I think that they can, and I think that
do we know how many defendants are out there in the universe that would fall into the category of being able to bring those kinds of claims?
No, and there's no way to, as Mr. Vastine said, there's no way to put a number on this, but what we can do is examine the circumstances that can give us some sense of what that would look like. And again, in Padilla, the court did just that and said, attorneys have been doing what we're saying, what we're now confirming is old law, that Strickland requires reasonable counsel to provide advice, and under Hill, including pre-plea, about the circumstances that a defendant needs to consider in order to make a voluntary plea and to knowingly and intelligently waive those rights.
It seems to me that we have some idea that there's a pretty large universe of defendants who might fall in this category just from the number of cases that we've gotten since Hernandez and now Mr. Diaz has been filed.
And I think, unfortunately, that's the result of the fact that these people have been unable to bring their viable claims of involuntary pleas as a result of the erroneous decision in Ginebra. And that's why the words of Justice Terrell are so prescient, because he says, better to correct this and eat crow than to perpetuate error. And the error that's perpetuated is that we would have however many, whether it's simply the defendants who are before the court today or whether there are more who have entered involuntary, invalid pleas. And there's no question that that's
here's my concern, and I come from a practical world. And I was a trial judge, and I did this as a lawyer. And what happens in big metropolitan areas like Miami, Jacksonville, Tampa, Orlando, is you have these bond arraignments. And at that bond arraignment, the prosecutor will offer a plea to the defense lawyer who will meet his client, public defender, maybe that day. And the plea will be open only for that day. And it may be a darn good plea that may not be available 3 months later, because the prosecutor by that time would have discovered far more things about the defendant that he or she did not know at the time. So what you're saying is, don't take the plea that day. Take the time to explain to your client this immigration problems, and then later on, 6 months later or whatever, suddenly he is facing or she is facing an additional 15 years or maybe life imprisonment. You got all these balancing things, and I think what you're expecting lawyers to do is to just meet with the client like you would with a privately retained client in your office. And then you will write your client a nice long letter telling them this is what's going to happen if you take this plea. You need to make this decision. That's not the real world. So what is a lawyer to do? What's his public defender to do when he or she is facing 20, 30, 40 cases in one bond arraignment session?
The public defender is bound by the very same Sixth Amendment counsel standards that everyone else is. And the meeting doesn't have to be in my office. It doesn't have to be in writing, but it has to be meaningful, where the attorney has an opportunity to fully explore with the defendant all of the circumstances that that defendant needs to contemplate if they're going to stand in front of the court and enter what this court demands, which is a voluntary plea, and that they make a knowing and intelligent waiver of all of their constitutional trial rights. And if that conversation cannot occur, then all of those pleas are going to be invalid.
Well, but here's the deal. Whether the Supreme Court understood the realities of what goes on in the courtroom in Miami, we're bound by Padilla going forward. So the public defender's office in Miami, whether they have an immigration specialist or they don't, seems to me that issue is settled. But let's go back again to this question that for 25 years that there's been settled expectations that a colloquy that included you may be subject to deportation was sufficient to make the plea knowing and voluntary. And I asked you, and you responded yes, that it was not necessary to change the plea colloquy. So it seems like you're saying two separate things, which is that the judge does what he or she is supposed to do, but that is not going to make the plea colloquy, the plea voluntary, unless the lawyer gives additional information. So going forward, I don't see how we get around not having some change in the plea colloquy if the issue is voluntariness. And what is your response to that?
The plea colloquy is ultimately a safeguard. It's a safety net to ensure that what the Sixth Amendment demands, which is where the real advice, where the real discussion and exploration goes on, that it's happened. And so the court is always going to have to take a leap of faith at some level that the attorney is doing what Strickland says, what all of our standards of professional engagement say that they're supposed to do. So in the end, The court can't absolutely guarantee the voluntariness of the plea. What they can do is to take certain steps to ensure that if something may have been missed, or perhaps in response to that warning, someone is going to say, wait a minute, I never talked about that with my attorney. At that point, the court can say, counsel, you need to have that discussion with your client.
I'm still not sure that you've actually responded, though, to this issue about retroactivity. Give me, under Witt, the best case where we've applied something retroactively, and then the case that's most difficult for you to get around. In other words, give us, because I know we've been through retroactivity lots of times, not recently. Seems to me more like the cases where we haven't held the new development to be retroactive.
First, I would say that Padilla is old law. Padilla is old law in the state of Florida, and so really the court never even needs to reach Witt, because Witt has to do with new law and whether we're going to apply new law retroactively. An old law is always applied to old cases that were contemporaneous with that law.
Wait.
Are you conceding that this is just a further refinement of something that already existed?
It's a rather unique situation, Justice Lewis, because on the one hand, it's old law. It's simply a restatement of Edwards and the law that was absolutely the law in this state prior to Ginebra. But yet, with regard to Ginebra, there's no question that this is not simply some evolutionary refinement. It directly conflicts with Ginebra and said, that's not the law. We don't define the scope of Sixth Amendment counsel by determining whether a consequence is direct or collateral. And so it's a rather unique situation that perhaps does not fall into any of the other cases that the court has looked at. Unquestionably, there have been very few cases that this court has found to be retroactive under the Witt analysis. But what I would suggest is that in this case, where the very purpose of Padilla is to ensure the integrity and the reliability of the plea process, the process that this state uses to resolve 98% of criminal cases in the state, that is a core concern that warrants taking what Justice Periente correctly notes may be changing how things have been done for a good number of years.
But now, as we get into the process, I mean, we run the scope from having counsel at all to what counsel must do, to what elements counsel must touch upon. And I think that's where the question was going, as to which of these fall into the category of Witt to become retroactive. And I think you really need to address that this morning, because I think that's where the issue is really coming up. So you really have to give it your very best cases that you have to demonstrate why that Witt element, the one that says if it's a mere refinement, as the state has argued, is not applicable here.
Unquestionably, what this court has recognized in Ginebra, what Padilla recognizes, is for non-citizen defendants knowing what the clear and virtually inevitable deportation consequences are, is perhaps even more important than knowing what the jail sentence is that the plea exposes them to. This court has recognized that in Ginebra, and that's what the United States Supreme Court recognizes in Padilla. And that's why this is such an important right. I can't point the court to a specific decision. Again, there's but a handful, if that, and the classic kind of paradigmatic case that all the courts talk about is Gideon. And it's interesting that Gideon has to do with affording Sixth Amendment counsel, as does this case. And in a case out of the 3rd DCA, an old case called Blatch, which is cited in our brief, the court said all cases dealing with the right of counsel should be retroactive because it is such a core concern of the criminal justice system, such that we're willing to eat crow and deal with the people whose rights have been violated up until that point in time, because it's what's central to what this court and what our Constitution hold is sacred to these particular proceedings. With regard to the...
As you're going through this, though, isn't the problem that it's not like in every case someone's going to get relief? And it's going to be an evidentiary... It has to be an evidentiary hearing. It's not a slam dunk, correct?
Absolutely.
Well, how do you expect the prosecutor, the public defender, the criminal lawyer to remember something that happened 20 years before to be able to say, well, I know I counseled this person or not? Isn't that a concern? In other words, the reliability of the proceeding, that, you know, these are not people, by and large, that are innocent. Most of them, I'm assuming, committed crimes, because I haven't heard one person say my client was innocent of this, and that's the miscarriage of justice. So they committed a crime, and now, 20 years later, they want the get out of the deportation with no other consequence. And I've got, again, I'm understanding what you're saying, but it's not hitting you're not addressing the effect on the administration of justice by somebody who validly pled guilty, is not saying they're innocent, who is therefore going to be have nobody who remembers the other side of the story.
I guess what the court said, someone who validly pled guilty, and that's fundamentally not what we have here. These are people who did not validly plead guilty.
Well, have you asserted your client's innocent? I don't know what his crime is. Have you asserted he's innocent?
But that's not in the record. What's in the record is that this is a defendant who had virtually automatic and clear deportation consequences, and indeed was in deportation proceedings at the time that he filed the motion. And oftentimes, that's what triggers the bell, because that's when people learn this. But
is there a publication or a list of offenses in Florida law that classify or qualify for mandatory deportation that can assist these public defenders in realizing that what his client is about to plead to will subject him or her to mandatory?
Absolutely. It's all in Title VIII of the United States Code, and it defines very clearly what are inadmissible, what renders a non-citizen inadmissible, and what renders a non-citizen...
Well, perhaps an immigration lawyer who's an expert in the area can compile the Florida crimes in this state that would qualify as a mandatory deportation and circulate those so lawyers can have them.
I think that kind of thing should have been going on, in fact, has been going on, and Padilla states absolutely needs to go on. Criminal defense attorneys need to be sufficiently familiar with the immigration code to be able to advise their clients that this particular plea will render you deportable, so that the defendant can make that knowing and intelligent decision.
Counsel, you have exhausted your time.
Thank you.
May it please the court.
Ms. Davenport, let me ask you this, because this case struck me as even more like Padilla, because wasn't Mr. Diaz basically told that if we could get a withhold of adjudication or something, that would solve your deportation problems?
That's what he alleges he was told, yes.
Okay, all right. So is that misadvice?
That would be misadvice.
Okay, and so this case really, in my mind, falls squarely within the parameters of Padilla.
Here's why it's different from Padilla. That's the only thing Padilla heard about deportation was, don't worry about it. This person was told under oath, I understand that this can be used and I am at risk of deportation. And let me get back to why that's accurate and the only possible advice he can really be given. I understand that there's these mandatory deportation. And right now, it's my understanding that this administration is going after people who commit crimes. That's where they're targeting their resources.
And this one really is as aggravated crimes. He's a burglary and aggravated assault,
right,
correct?
So the immigration specialists representing him now say that that's an aggravated felony. I don't know. I'm not an immigration lawyer. They say it is. I have no reason to doubt that.
So
the point is, it's not. This administration is going after people who commit crimes, and maybe that's how Mr. Diaz got caught up in that net. This administration. Will the next administration do that? We have no idea.
So he is actually in immigration proceedings now, Mr. Diaz?
That's what he alleges, yes.
Okay.
So
Mr. Hernandez was not.
Whether someone is adjudicated or not adjudicated has no significance in the immigration world? Am I correct?
According to the immigration specialists here, you can still be deported for that.
I got to tell you, I was on the criminal bench for 5 years, and that's a major misconception among criminal defense lawyers. They feel that if there's a withhold, that somehow immigration will not pursue that.
Right. And I don't know the answer. Again, from their case law, it sounds like that is inaccurate, and we certainly can't contradict their opinion that is inaccurate. And we don't know if that's what he was really told. Again, we're going on allegations in a pleading. We haven't had a hearing. But unlike Mr. Padilla, Mr. Diaz was told by the trial court that this plea can be used in deportation proceedings. After everybody knew we were going to withhold adjudication, it can be used against him.
But it would be pretty confusing if his lawyer said it can't be. And I haven't had the benefit of Justice Labarga's experience, but my senses about how these pleas work, especially if there's one after another, is that they may be in a bit of a fog when they're listening to the judge, and so you really want to have the lawyer as the backup. But let's go back to this retroactivity issue, okay? Because really and truly, I think that under Padilla, your argument that a maid subject to deportation is in a mandatory deportation offense is probably not going to be enough for the trial lawyer to escape an argument of deficiency. I think your better argument really is the wit analysis. Tell me honestly, first of all, are we talking about an evolutionary refinement or a change of fundamental significance?
We're talking about an evolutionary refinement.
And it's hard for me to think it is that, seeing that we said in Ginembra that there is no ineffective assistance of counsel, and we said these were collateral consequences, and now the U.S. Supreme Court is saying, nope, there's no such thing. We've never applied a direct collateral. We are talking about serious consequences. I mean, for 14 years, I've relied, not whether I've agreed or not, on the direct collateral consequence. They're saying, nope, it's a new day. But if we decide it's an evolutionary refinement, then there is no retroactivity analysis? Is that the first? So if it's not...
No, evolutionary refinement would be one of the three factors in considering whether it's a development of fundamental significance.
Okay, so if it's an evolutionary refinement, but then the next question is it a fundamental significance?
Evolutionary refinement is one of the factors in analyzing whether it's of fundamental significance.
Well, can you really, to me, so does the state concede or agree that this is a fundamental significance, that it goes to the essence? No, they don't?
No. Fundamental significance is the big picture. The three factors go into that. But here's why we don't concede that it's even an evolutionary refinement, why we don't concede it's not an evolutionary refinement. Because Ginebra wasn't the end of this. The next year we said, okay, trial counsel isn't obligated to become an immigration lawyer and tell their clients the details of this. But you know what? We're going to have the trial courts go in there and make sure that these guys are aware that the risk is out there.
But you know,
and all this does is changes who has to tell them.
But you know, accept that, and I've always thought it was ironic that we were having the same plea colloquy up in the Panhandle. You know, they don't ask whether someone is an American citizen or not. They go, whether or not you are, here it is. Well, so for 98%, I'm just giving a percentage, I have no idea, of the criminal defendants, they are American citizens. So that goes over their head. I guess we don't ask the question, well, are you American citizen? Because maybe the criminal defense lawyers didn't want that signal.
Exactly, right.
Okay. So we have the same colloquy up in Pensacola as we do down in Miami-Dade. As a practical matter, therefore, what you call the generic one becomes almost like one of those, you give your car to somebody and they say they're not responsible. It kind of just goes over you. So it seems that's why it's uniquely appropriate for the trial lawyer to ask the question, first of all, are you attorney-client privilege? Are you a citizen? And if they're not, now you're going to start to have some further questions asked.
Right.
It seems that the issue that if you have lived in this country, but you are going to be deported as a result, or presumptively deported as a result of the plea, that goes to the essence of whether you are going to want to take this plea or not. And I guess I have trouble thinking this is like just because we gave that colloquy that somehow it changes the significance of what happened in Padilla, what the Padilla case is about.
Well, first of all, and again, this goes back to the merits. Ineffective assistance of counsel is not, if you're deficient, boom, we're done. There is a prejudice aspect to this too. And for them to demonstrate prejudice, they have to show, but for counsel's misadvice, or in Hernandez's case, but for counsel's silence on this issue, I wouldn't have entered this plea. I would have gone to trial, and that would have been a rational decision based on the facts they had, the evidence they had, the sentence that was offered. And here's why they can never show this in Florida, and why Padilla shouldn't be.
I feel like you're now going back to going forward. If the colloquy is given, that there won't be an effective assistance, and I just wish you would just stay on the retroactivity part of why we shouldn't give it retroactive effect.
Okay, let me go back to the retroactivity then. I mean, it's tied together in the sense of an evolutionary refinement. The defendants in Florida were never completely in the dark like Mr. Padilla was. Since 1989, the defendants in Florida, including Mr. Diaz, were told by the trial court that there is a risk. Now, whether under Padilla that's sufficient, apparently there's debate about that, but be that as it may, now instead of Genebra, where we said counsel doesn't have to talk about this, now they do, but the information is going to come from counsel rather than just from the trial court. That's the change in the law after Padilla, and that's clearly an evolutionary refinement. It's in Florida because we were already telling them something. Whether that was sufficient, we would submit it was, but it's clearly, we've taken another procedural protection. Well, counsel needs to go further. So that's an evolutionary refinement. So that's the first factor that shows this is not a development of fundamental significance as that term has been defined by this court.
What about the piece on the affirmative misadvice? Under Florida law before Padilla, would that state a claim for ineffective assistance of counsel?
No, because it's affirmative misadvice about what we deem to be a collateral consequence, and there was no duty to give advice about that. There's no case out of this court saying affirmative misadvice on whether or not you're going to get your driver's license is deficient performance, because it's outside the scope. In fact, the only law we had here was Genebra, where we said that was the claim. They said, he didn't tell me about this. He had a duty to, and this court said, collateral consequence, we're not going to have those coming up. You only have to be effective as to these direct consequences. Okay, so this is the first time that a court has said counsel can perform deficiently in Florida by not talking about immigration consequences. That's an evolutionary refinement. The second factor is the extent of reliance on the old rule. This rule has been in place since 1989. That's a long time that this court has allowed these cases to go forward. We don't have statistics. I don't know how we could possibly come up with statistics, but just from a common sense understanding of how things work and the nature of the people in Florida, there's a lot of aliens here. That was a long time to rely on this rule. We're talking about a lot of cases. And
and I appreciate you representing the Attorney General's office for the entire state on this. Justice Stevens, in his majority opinion, talked about there's only, if there's 100% cases, and this is how many are guilty pleas, and habeas only come up with a certain percentage. We have no idea. When we held Higgs, we had the Higgs cases, maybe we didn't have an idea what we were talking about because we were talking about almost every conviction. But here, we've got, Padilla's been around for 2 years. Now, that doesn't mean everybody that must have thought they had relief filed.
Right.
But do we know just in cases in the district courts of appeal, as it's been 2 years, whether we're talking about thousands or hundreds or under 100? And is that at all the idea that floodgates for retroactivity is a finite number? When we're talking about somebody's ability to stay in this country, it's couldn't be of bigger importance, depending on where they would be deported to. So should we know that, or is there a way to find out some estimate of the numbers?
The only thing that I could find out easily was, as of last week, there were 47 district court opinions mentioning Padilla.
Now, you would not, if we were talking about under 100 cases, would you think that is, I guess the third one is the effect on the administration of justice, that under 100 cases of people that either were misinformed or did not realize they were subject to mandatory deportation? Because again, if it's not mandatory, then the may be enough that we have. If it was under 100, that would be the kind of effect on the administration of justice that would militate against retroactive application?
If we could realistically say that this would affect under 100 defendants, I would say that factor would weigh in favor of a finding of retroactivity. But let me say this:
and I appreciate
47.
I appreciate the state's candor and your candor in this, because this is a difficult balancing that we're doing, and we're doing it as a result of the U.S. Supreme Court making a change in the law, and not this court making a change.
So there's 47 district court opinions. That doesn't count the PCAs. That doesn't account the cases that have been stayed before briefing. We're talking 47 opinions as of last week. I would submit that is the tip of the iceberg. When you're talking about applying this retroactively, that would mean 50 years ago I entered a plea, I'm still in this country. You know what? I can bring that claim because it applies retroactively to everybody.
If you've been in this country for 50 years and you put your name up in a case, if I were that person, I might think, I've been in this country 50 years. I think I'm almost to the point where I may live my life here. I don't think I want to have my name in lights in a district court of appeal opinion so that I'm the next in line for the INS to come get me.
That's true, and can I just say that illustrates the difficulty of predicting whether or not somebody is going to be deported, this mandatory deportation. It illustrates why the risk that we talk about in the plea colloquy is really accurate, because some people have been here 50 years. And some
we're
of
going
it
to keep
is,
on going
there's
around
so
on
many
this, but on these mandatorily deportable offenses, I think the U.S. Supreme Court was very clear that you really need to tell the person, as the lawyer going forward, that this is a presumptively mandatory deportable offense. I cannot tell you when you will be deported or if. This is a risk that you have to decide in deciding whether to plead guilty. Isn't that what you
would agree that is exactly what counsel is required to do now, and I would submit that that's also exactly what the trial court has been doing in Florida for 20 years. But going back to the Witt question, the effect on the administration of justice, there are, when you consider the number of pleas in Florida, the number of aliens who live in Florida, the number of people who are potentially deportable as the statute stands today, we are talking about a myriad of cases. I don't have the statistics. I don't know how we could accumulate that statistic. But just from a common sense perspective, if you open this up, everyone, unless this court holds that prejudice cannot be demonstrated, which is what we would submit it would, which would eliminate this Padilla problem, every one of these guys would be able to bring a pleading, and they would have to have an evidentiary hearing. Everyone would have a hearing. We'd have to track down counsel. Counsel is not going to remember realistically what they told this client who entered a plea 20 years ago. We're not going to be able to prosecute them again if they invalidate the pleas. This is stale claims. This is exactly what this court already addressed in Green when we tried this little experiment of having these guys come up years later after their pleas, and we'll address it then. And that was plea colloquies, which is a record. Here we have where we were counting on their remembering by defense counsel. So that's a lot more onerous to the state. Nobody's going to remember these things. In Green, this court said that is completely unworkable. We need to have this within 2 years so that we have a window. And that's exactly what should happen here. This should not be applied retroactively. All three of the Witt factors weigh against a finding that this was a development of fundamental significance. If you look at the cases where this court has found that Witt does not require retroactivity, it's big cases, it's important cases, and we aren't saying that what is happening to this defendant isn't important to this defendant. We're talking about Crawford, Apprendi, Ring. Those are big decisions. They are important to certain defendants. But under Witt, we don't apply them retroactively. In a perfect world, everybody would have the benefit of every decision that comes out. If it helps them, in a perfect world, they would be able to bring that. But that is just not realistic. And as this court already decided in Witt, you have to balance this. You have to consider that there is a need for finality in these cases. You have to consider that it doesn't do defendants any good if their cases aren't final either. It's not good for the victims, and it's really not good for the system. So there is an interest in finality that overrides the interests of an individual defendant. He keeps saying that the plea was involuntary. Again, we had a plea colloquy where he knew about this. We would submit they can't even show ineffective assistance of counsel because they can't show prejudice. But be that as it may, it certainly should not apply retroactively. Ginebra controlled his case. Counsel was not required to give advice at the time he brought the plea. Padilla does not apply to him. It was 10 years ago. It's time for him to be final. Thank you.
We thank you both for your arguments. I'm sorry, counsel, you had exhausted your time. I'm sorry, you had exhausted your time. I'm sorry, you had exhausted your time. We thank you both for your arguments, and the court will now stand in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
Now come to the third case on our docket today, Castano versus the state of Florida.
Good morning, Your Honors. May it please the Court, my name is H. Manuel Hernandez, and I represent Ms. Castano in this particular matter.
Mr. Hernandez, as you start off, in going through the briefing and trying to be sure really understood what, trying to understand this case, it seemed a little different because of the preschool, the caretaking situation, and the child neglect charge. Is it agreed with all the parties, the state and the defendant, that this immigration status of this person is such that it falls into the Padilla category?
I'm sorry, Your Honor, I don't understand the question. You say
well, because this is a different charge. Correct? We still got child neglect. It was a felony, as I understand it, correct? Yes. Is this charge that she was facing within the same category of deportable behavior?
Absolutely.
And with her marriage status, as it was, is she in that category?
Yes.
Okay. It just was not as clear to me as the others that we've discussed this morning, so I want to be sure.
In my brief and in my reply brief, I've laid out in the cases Martinez, it's an 11th Circuit case which specifically addresses a case. It's a federal appendix case, but it talks about someone prosecuted under the very same statute that Ms. Castano was convicted of.
Okay, fine. That's right. Keep going. I don't want to take your time.
Actually, you also have, while you're haven't started yet, this also seems to be in a different posture because she pled guilty in March of 2009, and she moved to set aside her plea based on an ineffective assistance of counsel claim in November. So she was within the 2 years. Padilla came out before the order. So I'm going to ask the state this. I don't think this is a retroactivity issue because she raised an ineffective assistance of counsel claim timely, and Padilla was pending at the, it was a pipeline case. So we don't have a retroactivity issue here, correct?
The Padilla decision came out, I believe, March 31st, if I'm not mistaken, of 2010, and the judge's order denying was March 10th, 2010.
Yeah, but the issue is this is a friendly question for you. When there's a pipeline case, it was pled that counsel was ineffective based on not, despite Ginembra, you or her attorney, were you her attorney?
No.
Her attorney filed a motion to set it aside once she found out that she would be subject to deportation.
Yes.
All right, so we don't have the retroactivity issue here, but isn't this different because what does the record reflect about what her attorney told her?
She was charged with the felony child neglect, and she claimed her innocence. Although I don't believe, and you asked questions in the previous case regarding innocence, the Supreme Court, and I think the case law is clear. I've cited in my brief at page 19, Kimmelman versus Morrison, guilt or innocence really isn't the controlling factor on these particular issues of right to effective assistance of counsel.
No, I understand that, and I was raising it more about whether there's an injustice in when you go back 20 years.
Yes, and I'll answer your question, but she filed within 8 months after the plea and sentence. She immediately filed an appeal. That's when I came into the case. When the appeal was lost, we immediately asked for, once we asked the 5th DCA to correct its opinion, to clear up the may and the is issue that required by Padilla, and they denied that request. Then we filed invoking this court's jurisdiction. So the record is very clear that Ms. Castano has prosecuted this case and moved as quickly as possible, and I would respectfully submit that shows her belief in her innocence and the fact that she didn't realize the immigration consequences.
Well, what about, I thought Justice Pariente's question really wasn't your client told by the attorney that she actually should consult with an immigration attorney on this case?
And that's not enough.
Yeah.
On the Padilla, that's not enough to just say go talk, punt go talk to an immigration lawyer. When the consequences are clear, truly clear.
But I mean, that makes this case somewhat different from these other cases. I mean, he obviously told her that there possibly were immigration consequences. He may have said, I don't know, in the immigration laws, you should consult with an immigration attorney. Seems to me that does make a difference in this case as to whether or not, counsel at least attempted to give her some information about immigration.
Well, the information in this case, it is different to the extent the court has a full record. You have a transcript of a full hearing that was held, and you have the testimony of Ms. Castano denying that she was told anything about immigration consequences, that she was summoned to court, didn't even know why she was going to court, and that's unrebutted. And then when she shows up, she got there early, her attorney shows up late at the last minute, gives her this plea form to sign, and it pleads.
Is this a plea of convenience? I mean, did she plead guilty, or did she plead no contest, or what was this?
Alfred. Yeah.
Give me 1 second, Judge. She pled guilty.
Can I go back to what Justice Lewis began with on this whole question of whether this particular crime falls under the mandatory deportation category?
Yes.
In the immigration world, this so-called mandatory deportation, is there any leeway, any discretion at all? Because we have here a lady who was running, I believe, a daycare center. She had a business, something we want people to do in this country, have a business. And she had a bunch of children, and I believe the allegation is that one of the children got away and was just wandering around the neighborhood. I mean, that hardly seems to me to be the type of crime that we would include in this list of mandatory deportation because they create this danger to this country. Is there any room, any maneuvering room at all in the immigration world?
There used to be. Padilla talks about it. I think this court in Green and Pert has recognized the drastic consequences to immigration status these days from conviction. And I cited in my brief the various cases. The reality is, no. The statutes now, if you fall within one of these statutory categories that you're subject to deportation, it's pretty much automatic. Now, whether they get to you today, this year, next year, like Justice Pariente talked about, you have this sort of Damocles hung over you while you're in this particular status. The bigger problem, aside from the fact that under immigration law there's no discretion, judges don't have discretion. In the old days, you can go to a federal judge. You can go to the 11th Circuit and try, and they can look at the facts, as you just, Justice LeBron, discussed, and perhaps, try to temper the immigration laws with justice and try to be fair depending on the facts of the case. Congress took that power away from them completely now. They don't have it. And that's why this is such an important case and why this is so important for this court to have to deal with. They don't have it. So you get convicted. And now they go back, too. It's not only, we're talking about retroactivity. This law applies, the immigration law applies retroactive. So back 20 years ago, you got in trouble when you were a kid for selling a few pills. Back then, there was no problem. You weren't going to get deported for that. Now it is. And then when immigration gets to you and you've got that conviction, they go after those people and they deport them for something they did 20 years ago.
How would that work? Because no lawyer could have advised them about the future action of Congress that was going to be retroactive. I mean, how could they?
That's the immigration law as it sits in this country today in terms of...
But I'm asking about how would that figure into our analysis of the ineffective assistance of counsel? Even if we applied all this retroactively, if we applied Padilla retroactively, how would it deal with circumstances like that arose before those changes to the law, I think, were in 97?
It would give you the opportunity, or a judge, the opportunity to do what federal judges used to do. Look at the individual cases and consider that factor. And consider the factor that 20 years ago, that particular defendant with that particular crime would have been able to get some type of relief from a federal judge. And now 20 years later, 30 years later, has a full family here, has children in school, they want to deport him and send him to a country he may never been in since he was a child. It's a tragic situation that we're in. It's unfair, it's unjust, but that's where we're at.
Well, but what we're really talking about is whether your client, Ms. Castano, is entitled to relief. Now, you said there was a full evidentiary hearing.
Yes. And
did the judge not reach the issue of the Strickland claim? I mean, in other words, you said she testified that her attorney didn't tell her anything. Did he resolve or she resolve the credibility of that testimony?
The judge in her order basically relied almost exclusively on the what transpired at the change of plea hearing on the 3.1728.
Okay, so if in this case...
And just to be honest with you, I apologize for interrupting you. There is some language, I think it's confusing, at the end saying nothing that happened at the hearing changes my position. But she says that right after she's talking about a different issue about the DCF, advisement about DCF consequences.
Yeah, well, that's what I was also just going to ask you that, which is that she owned and operated a daycare center. So she's charged with child neglect. Doesn't she end up under the state rules losing her license for having a felony child neglect?
She did, and then she got it back. As I recall, she got it back. That was one of the issues. It's not before this court, but yeah, that was one of the issues. She lost it, and that was one of the issues she raised in her 3850. Nobody told her that. She thought, and going back to your original question, Justice Barrenta, the lawyer did say, go talk to an immigration lawyer, and he gave her basically what gossip on the street. I hear that everybody's getting deported these days. That's what he testified. Basically, is what he told her.
Was this a privately retained lawyer?
Yes, Your Honor. But he also said, and at least according to her testimony, and it was unrebutted, that he also told her, she had nothing to worry about. All she was going to have to do is pay some money, and everything would be just fine. He said her concern was not going to jail. Okay, and again, based on the fact that how quickly she's moved and how she's gone, we're sitting for the highest court in the state, and she's wanted to prosecute this. It makes very clear she did not fully understand.
On mandatory charges, are there under immigration law anything that would change the mandatory nature of those offenses? For example, differences in status or different classification somehow in immigration law, or is there anything that could change that?
I don't believe in terms of Ms. Castano, no. No. It's my understanding, no. I'm a criminal defense lawyer, and I'm not an immigration lawyer, but my understanding as far as Ms. Castano, no, there is nothing.
What about generally?
Generally, there are certain cases and certain situations, depending how long you've been in the country. But when it comes to aggravated felonies and these mandatory deportation statutes, my understanding is the answer is no. If you fall under that, if you're selling drugs, you're deported. I, as a criminal defense lawyer, and I appreciate the state's great concern that I'm not going to be able to figure this out, but I know and have known for many years that if you get convicted of a crime of selling drugs, you're gone. I don't care who you can get as your immigration lawyer.
And there's no difference in the status of the defendants that could somehow alter that in any way?
No, the fact that you've been here for 20, and I've had clients that have been here for 30 years and got deported depending on their conviction. They've been here for 30 years, their wife's an American, their daughters and sons are Americans, and this was their first criminal conviction. They're gone. If it's an aggravated felony, over $10,000 in a fraud, a sex offense, there are all types of these statutes. As I say that, it's not something that criminal defense lawyers are not going to be able to deal with. And again, I stand before you again as a criminal defense lawyer, from the bottom of my flat feet to the point of my bald, pointy head. That's what I do every day. So when I look at this particular situation and what Padilla decided, it causes me some concern as to what my responsibility is going to do. But we learn. We have to know what minimum mandatories. If you look at the drug statute, that's a complicated statute. We have to figure that out. There are all types of other consequences that we have to know. This is what lawyers do. There'll be training. There'll be, as Justice Barretta talked about, there already is. There are already seminars where you get handouts as these are the offenses. Immigration lawyers come in.
So what do you tell your clients? The client who is charged with, say, selling LSD, and he's offered a 1 year probation and a withhold, waive cost of supervision, waive everything, just plead. He's offered that at a bond arraignment. What do you tell him?
I tell him, and I've told him, I'll give you a worst case. Guy was sitting in jail facing 25-year minimum mandatory, and they offered him probation, and he was in jail, wanted to get out. Get out today, plead guilty, get out today. And I told him, you can do that, you get out. You're going to be deported. And he stuck around for 5 or 6 years and calls me, hey, they want to deport me. Well, that's what I told you, and you had to make the decision. And in that case, I thought we could win the trial.
But do you make that? Do you give that advice based on the fact that you know that selling LSD is a mandatory deportable? What about the cases that fall in the crack that you don't know? What do you tell them in those instances?
They addressed that and said, in that case, the warning that we use now in the 3.172 that you made is sufficient. Padilla and the Supreme Court recognize there are going to be cases. And that's where it becomes dicey. Not on the mandatory. The mandatory, no matter how long that list is, can be determined, and we can learn it relatively quick. Criminal defense lawyers, can be fairly bright at times. But it's that dicey part where we don't know. That's when it gets to be, and that's when you have to go to an immigration lawyer. So my advice to everybody is, if I know aggravated, if you stole $1 million from the government, you're deported. It's over, okay? If you get convicted of this, whether we go to trial or whether you plead guilty, you're going to be deported. I tell them that. And I tell them, go talk to an immigration lawyer, just to make sure. But if they don't, and half the time they don't, they have to make that decision. And the reality is, many of them are going to enter their plea because they want to avoid jail. But that's not...
Here, let's just make sure, with Ms. Castano, and I think you answered this, that the child neglect, a third-degree felony, there's no question in the record that that's a mandatory deportable offense?
Again, Padilla was not decided at the time of that particular hearing. Yet, there's no question in the record. He's put, I believe, in the petition, Mr. Rodriguez, who represented her, put the fact that she's now subject to deportation, mandatory deportation.
You've been very forthright. That sounds like an equivocal answer.
That's the first question I ask out of the box.
Well, there's no question she's deportable.
No, that's not what the question is. Is it mandatory?
Yes.
Well, why did you answer her equivocally?
I'm not, well, I apologize if I sound equivocal. I just don't remember what page in the petition he said it.
But that's a question of federal law. That's right. Not what, that's, if I'm understanding what the question is. It's a question of federal law, whether she is subject to deportation in the same way that the defendant in Padilla was subjected to deportation. I mean, this is something that's mandatory. If there's any out, it's very limited. And if they decide they want to deport you, if they get around to you, you're gone. Is she in that same category?
She is
under federal law,
mandatorily deportable under federal law, and my duty under Padilla as her criminal defense lawyer is to tell her that before you enter a plea, you have to understand.
So if we go and look at the federal law, we're going to find this offense in the category where the same category that Padilla's offense was in.
If you look at
the same list of categories, anyway.
Yes, it's 8 U.S.C. 1252, page 27 of my brief. I've cited the statute that says it. I've also cited the Martinez decision and the Solem decision, which is a matter of Soram, which is an immigration opinion, and then the Martinez versus the U.S. Attorney General. That's at page 29 of my brief. And the U.S. versus Attorney General is right on point. In terms of she's deportable. She believed in her innocence. She was, I see I'm running out of time.
You are.
She believed in her innocence. She did not want to plea. I believe that's unrebutted in the record. She was not given real advice in terms of immigration consequences. She was given legal gossip and confusing, and that's important, confusing advice in terms of nothing's going to happen, you're just going to pay some money. And she moved quickly. As soon as she was able to determine, she got a new lawyer, and she came before the court. So she fell certainly well within the 2 years. I got 30 seconds to come back up, I guess, and I'll Try and sneak in 40 seconds if I can.
May it please the court. First of all, in my opinion, this does require that Padilla be applied retroactively because her conviction was final.
And I thought of this, and I know we have cases on it.
Yeah.
Padilla, when Padilla filed his motion for post-conviction relief, which was within 2 years, presumably,
Right.
of his conviction, Padilla hadn't been decided.
Right.
Okay. When we call these pipeline cases, when this woman, Ms. Castano, filed her motion within a few months after her conviction, she raised the identical issue. She just was otherwise banned by Ginembra.
Right.
And therefore, but before the judge's order even came out and before it went on appeal, Padilla had been decided. My belief is, and again, is that's not a retroactivity issue. That is the law that was, first of all, the judge could have applied that law, but certainly the 5th District would have been appropriate if they hadn't decided on the other issue in applying Padilla. I don't see how she's in the exact situation as Mr. Padilla is.
Well, this wasn't argued by the defendant, so I'm not positive about this. But
close. Think about it logically.
But my understanding is pipeline cases are cases that aren't final yet, and her case was final.
Well, how is it?
So she goes under Ginebra.
It was decided before the appeal.
But it wasn't a direct appeal. It was a post-conviction motion.
You wouldn't raise an ineffective assistance of counsel case for a conviction. Nothing changed about the validity of the conviction. What changed was the law on post-conviction relief, not on the trial or the guilty plea. Do you see what I'm saying?
I do see what you're saying, and I apologize. I am not sure what the answer is. I thought that pipeline cases were cases that were not final.
And we don't have an ineffective assistance of counsel claim for post-conviction, but I think that if this would be, if she's really in the pipeline, it would really not be a fair thing if Padilla should apply. Now, can you tell us?
If she's in the pipeline, I'm not sure she is, as pipeline has been defined, but I'm not sure she's not either. Again, this wasn't argued, so I'm not sure.
What would be your argument as to, is this one of these mandatory deportable offenses, or is this different?
This is, again, illustrates how difficult immigration law is. This is supposedly a crime of moral turpitude. A crime of moral turpitude is if a deportation proceedings are initiated, then there is no escape from that, if they're initiated.
Well, again, now we talk about how difficult this is, and I think that it was very illuminating to hear from Mr. Hernandez. You know, maybe we do expect a lot out of criminal defense attorneys, and some of them get paid the big bucks, and some of them don't, and we don't make a distinction about the kind of effective assistance of counsel they get. Right. They all get the same, whether they give it to the highest paid, the attorney that charges $100,000 and gives them that plea. It would be a sad fact if Ms. Castano was actually, she was charged with, there was a child that said under her care was found wandering in her neighborhood, and we don't know the facts. But this isn't she owned and operated daycare, so she was obviously a legal immigrant.
Right.
She was married to a United States citizen.
That's what her attorney testified that she told him.
And she asked within less than a year, 6 months of this plea being entered, to set it aside because she did not understand what might befall her. And just like you made a very compelling argument, I thought in the first two cases that we can't go back 20 years and correct this. This one seems to me to at least have to go back to look at whether there is deficiency, which it seems that just based on this record there might be, but then on the prejudice prong, does this undermine our confidence well, that's not even quite how you say it, under, would she not have pleaded if she knew that she could be deported? And she said she wouldn't have pleaded. She goes, I was innocent. How do we not grant her relief in light of Padilla?
Because we don't just grant relief, we remand for a hearing.
Well, okay, so
she had a hearing.
Okay, but did the judge decide the ineffective assistance of counsel?
Yes, and rejected it. Now, but they didn't reject it based on Genebra, which they could have, and I'm surprised they didn't. It's interesting what Mr. Hernandez said he would have told her, and what the attorney testified he did tell her are almost identical. The attorney testified that he's not an immigration lawyer, but he had heard, it was his educated opinion, that even with the withhold, the government was actively seeking to deport people. That's what he testified he told her.
Now
he also said...
Let me ask you a question about what defense attorneys are going to do going in. Do you think that it is that I might know as a person on the street that INS is getting tough, that an attorney saying it's not my responsibility, go find somebody that knows this even though I'm charging you, that is what Padilla says is appropriate for an attorney when it is a mandatory deportable offense, to say, I hear on the street that the INS is getting tough?
Again, what is a mandatory deportable offense? And I know we keep coming back to this prejudice prong, but let me finish what he said. He said, I'm not an immigration lawyer. In other words, this is not my area of expertise. This is complicated by the fact that what is a crime of moral turpitude is not obvious to us. I mean, you can look at it as this kid was wandering in the street, big deal. You can look at it as it's child neglect, that's a felony. That requires some legal research to figure that out. And there might not be an answer in every case. Now, he cited cases that seemed like they were pretty on point, so there is an answer in this case. So he said he had heard that they're going to actively...
But we're really talking about this case. I mean, we're going to have to... This is something I can see, seminars, I can see, maybe CLE kinds of things, and maybe the colloquy needs to be changed to at least list the mandatory deportable offenses. But we're, at the least here, shouldn't it go back for a evidentiary hearing or a reweigh on in light of Padilla?
We already had a hearing. Unlike the earlier cases where all we had was allegations, and somebody alleged they didn't tell me, we don't know if that's what actually happened. So you can't evaluate really deficient performance without assuming the allegations are true. In this case, we don't have to assume her allegations are true because we had a hearing on this issue. Why the trial judge ordered that, I don't really understand. You'd think they'd just toss it because of Genebra, but they didn't. This trial judge had a hearing. They asked about what was said about immigration consequences. This counsel said almost exactly what Mr. Hernandez said he would have told this person. You should consult with an immigration lawyer because this is very complicated. But I hear, even with the withhold, which is what your offer is, that they're still actively seeking to deport people. So she was told by her counsel that she is not only deportable, but they're probably going to come after you.
But Padilla applies to mandatory offenses, right?
Right.
Since you said it relates to moral turpitude, Padilla talks about what you can look at the face of the statute to see what is mandatory deportable. And if you cannot look at the face of the statute and figure that out, is a claim for moral turpitude one in which it's unclear, therefore you don't have to give that instruction?
That's exactly right, Your Honor. Moral turpitude, what that means goes well beyond the face of the statute.
What would you have to do to figure that out?
He'd have to do case law and research what the law is on moral turpitude and try and find a case that lined up factually.
Under federal law, Florida law?
Under federal law.
Because
this is a federal case. Immigration is a federal matter. So he would all of a sudden have to start researching federal on this issue. It's not apparent on the face of the statute, and you're exactly right. Padilla drew that distinction and said, You don't have to go further. Let's tell him about the risk, which is exactly what he did. If anything, he went a step further than that. The trial court told her you can be deported. Again, we get back to the trial court, so there's no prejudice. But the attorney himself testified at a hearing.
What the attorney said, even if we were to decide that that's somehow deficient, that question. But if we did decide that, wouldn't that also weigh in the scales on prejudice pretty heavily? I mean, if the attorney's there saying, look, they're deporting people, they're aggressively deporting people or something along those lines, then it seems like that's enough of that. That's not just a, well, you may be deported. That's more of a wake-up call that would weigh in favor of finding that there was no prejudice.
Exactly, because she has to demonstrate, but for counsel's misadvice, and I would submit there's no misadvice here. Apparently, some assert that under Padilla you have to use the words mandatory deportation. But let me say, if I'm a client and I hear mandatory deportation, my response is going to be, what does that mean? And the answer is, well, right now, this administration, as this guy told Ms. Castano, is actively seeking to deport people even with a withhold. Now, that could change tomorrow. But they could cut their budget. The immigration law itself could change. They could change and take out moral turpitude or define it more specifically. And the thing about immigration law is it applies to everybody. There's no ex post facto claim here. So we have Congress can change the law. Congress can change the allocation of resources. The president can change how they're focusing the immigration enforcement. The relationship with your country of origin.
This, most respectfully, this really seems that you're trying to debate the Padilla issue again. And that's not for us. What we have to do, and you understand that, is read this opinion and apply it to our as humanly as possible, as best we can. And it just doesn't get into all this kind of stuff, does it? What it tells us, that if a lawyer looks at the federal statute, and that statute says that it's, as I'm reading it, says it's mandatory that you be deported because it's in the statute. It doesn't say you got to get into May or what. If it's in there, then that's what a lawyer's supposed to do. It could have gone into and did not. You have to read all the case law. As a lawyer, you think you would anyway, but it doesn't say that. It talks about clearly on the face of the statute, does it not?
It does, but here's the caveat. Number one, the situation they were faced with, that is the only information he had, was blatantly inaccurate, which is not the case of any of these Florida defendants who complied with the rule. Here's the other thing. Padilla didn't have it, so I would submit the court is silent on what happens in a situation like Florida where we are already telling them about the risk. The only things we have on that, we have footnote 15 where they cite our rule with favor and say, this tells them about it already. See, we're not going out on a limb here. Defendants are told. And we also have subsequent cases, and if you look at Lafler, which came out after Padilla, they said, you know what, if you talk a defendant out of a favorable plea bargain, that's ineffective assistance too. So we have that, but they also have Missouri versus Fry, and there's language in that case that talks about what Padilla said, and pardon me while I read it, it says, Padilla illustrates that there may be instances where claims of ineffective assistance can arise after the conviction is entered, and they're talking about plea bargaining here. Still, the state and the trial court itself have had a substantial opportunity to guard against this contingency by establishing at the plea entry proceeding that the defendant has been given proper advice, or if the advice receives appear to be inadequate, to remedy that deficiency before the plea is accepted and the conviction entered. That's language talking about how Padilla is going to work, how plea bargains work, and that came out after Padilla, and I would submit that supports the state's position that you can fix this in a plea colloquy, at least as far as prejudice goes.
Let me ask you this, but about this case.
Okay.
This case, you have already said, we had an evidentiary hearing in it.
Yes.
Was the argument made, because it seems to me now you have made the argument that since this is a moral turpitude, it isn't so clear on the face of the statute whether or not this is a mandatory deportation. That's what you're saying today, correct? Yes. Was that the argument that was made before the trial judge in the evidentiary hearing?
Well, the trial judge didn't have the benefit of Padilla, so we didn't get into what is a mandatory deportation and the
Was there a request for rehearing after Padilla came out?
No.
Padilla came out while this was still pending, correct?
Yes.
And so
I believe
was
it was
there
after
any...
the trial court's order, but before the 5th DCA.
So there was no request for anything, any kind of relief once Padilla came out?
No, and they never requested in the 5th that this be remanded for another hearing. But what would the purpose be of another hearing? Because we already know what counsel told the defendant, and that's why we have these hearings.
Well,
what did counsel really say?
Let me ask you something. First of all, we have the 5th District opinion.
Mm-hmm.
The 5th District opinion says that this court previously aligned itself with the 4th District, which held that prejudice arising from counsel's misadvice regarding immigration consequences is cured when the trial court gives the deportation warning in Florida Rule of Civil Procedure during the colloquy.
Right.
If we disagree with that and agree with the Hernandez decision, okay, then your argument that as a matter of law it's cured goes back to whether in a particular case as a matter of fact prejudice isn't established. And what I don't know, and I have to look at the trial judge's order, if the judge made a credibility finding as to what the trial lawyer said happened and what Ms. Castano said happened, because that's what we expect at evidentiary hearings when something, about what. So was there a credibility determination made?
There was a rejection of her claim and the statement that nothing at the hearing changes my opinion on this issue. Nothing expressly said, I believe the attorney and not her.
So it does seem to me, and maybe they've waived this by not raising the issue that Padilla applies, but that what we expect in an ineffective assistance of counsel claim, because prejudice is a mixed question of law and fact, is that if we have a dispute as to what Ms. Castano was told and the attorney says one thing and she says another, that's what the trial judge does, is resolve that dispute.
Right.
And it doesn't seem that because the trial judge and, more importantly, the 5th District relied on the plea colloquy as having, as a matter of law, refuted prejudice.
Well, the 5th District, the appellate court was required to affirm the trial court's order if there was factual support in the record. So unless the appellate court says we believe the defendant over the attorney, they can't reverse that finding.
That would be true if that's how they were deciding the case. But I just read from you that what they decided it based on is that they aligned themselves with Flores. I mean, we're here because of conflict between the appellate courts.
Right.
So you're the state, and you've been consistent. You would like us to announce a rule that is a matter of law that if you get the plea colloquy that says you may be subject to deportation, even in a case like Padilla where it's mandatory, that is sufficient as a matter of law going forward, backward, to cure prejudice.
Yes.
That's what you want.
That's exactly
okay,
right.
And that's what the 5th District ruled. So
right.
But if we decide that that Padilla is clear that if it's mandatorily deportable, may be subject to deportation is not enough, then we've got to go back in this case and see whether the judge actually did, not having the benefit of Padilla at the evidentiary hearing, needs to reweigh it in light of Padilla.
Well, no, and here's why. Because Padilla, whatever it says about mandatory deportation, also says where it is not clear on the face of the statute, you have to tell them there's a risk. So whatever we do with drug offenses, when you have a crime like this, which is a crime of moral turpitude, that is not clear on the face of the statute. And Padilla itself says, deferring to Justice Alito, frankly, and his concerns about defense lawyers becoming immigration lawyers, they say, if it's not clear, of course we're not requiring you to go above and beyond. You have to tell them about the risk.
I thought you said that you conceded in this case that if somebody looked at the law, there's a case clearly on point out of the
11th Circuit.
11th Circuit.
That's not the face of the statute.
Well, but are you saying going forward that an attorney faced with this case tomorrow is going to be able to ignore the 11th Circuit case and say, I hear on the street that this is or isn't deportable?
I'm saying, as Padilla said, where you have to go beyond the face of the statute and start trying to figure this out. And remember, this is complicated further by the fact that she told him she was married to an American citizen. Who knows how that affects deportation and whether that makes it mandatory. I think that's a confusing area of the law. But face of the statute, this is Padilla, not me. Padilla says if it's on the face of the statute that you can't tell, you need to tell them about the risk. And she was told about the risk by her attorney. She was told about the risk by the trial court. That is all you need for Padilla. So even if this court finds otherwise in drug cases or things where the face of the statute makes it more apparent, it's clearly enough under the Padilla decision itself because it's an amorphous concept and it's not on the face of the statute.
Thank you.
Thank you.
And I'll give you an additional 40 seconds because opposing counsel got an additional 40 seconds.
Thank you, Your Honor. In regards to Justice Lewis's question, page 69 and 74, paragraphs 13 and 27 of the petition, he did allege that it was mandatory deportation. So any equivocating I may have done was unintentional. I apologize. I want to correct this idea that somehow the procedures in Kentucky and Florida are different. And I put this in my reply brief, and I attached a form. It's almost identical. And the United States Supreme Court basically rejected what Kentucky did based on those same advisements. And as this court has noted during questioning,
But what do you say to this argument that was just being made about this category of moral turpitude? That's the category here that would catch your client. Not being something that would be obvious on the face of the statute.
I don't recall anywhere, and they may talk about face of the statute, but I do not believe that the standard of Padilla is that you look at the face of the statute and you know automatically that's mandatory deportation. No face of any statute is going to tell you that. You're going to have to, you're a lawyer. You need to go the next step, find the case. In the 11th Circuit, go to 8 U.S. Code 1227, look at the list of offenses. It takes 15 minutes, 5 minutes, and it requires something more. That's why we're lawyers. That's why people come to us and pay us to represent them, or we get appointed by the court to give them legal advice. And it requires more than just looking. I don't think any lawyer, I don't think an immigration lawyer is going to be able to just look at the face of the statute unless they've studied it and they know. Like I know. Trafficking in drugs, you're going to be deported. I don't even need to look at the face of the statute. Just tell me what you're charged with.
But doesn't the statute have a list of, I thought it was like about 20 of them that do indicate that these are mandatory, these are offenses where you would have mandatory deportation?
Yes.
Okay, so isn't that what the Supreme Court was talking about when they were talking about looking at the face of the statute? That's the language that they used, isn't it?
If they're talking about looking at Title 8 and being able to figure it out fairly easily, yes, I would agree with that. I don't agree, if I understood Justice Paulson's question, that you look at the face of a statute charging felony child abuse or child neglect, and that you're going to know just by looking at the face of the statute that's automatic deportation. Perhaps I misunderstood the question.
Well, that's my understanding of the Padilla. I thought that what they were requiring was that you advise a client of the mandatory implication of a statute if that's what it said on the face of the statute. And I agree that all defense lawyers can, and maybe under Padilla will have to become true experts in immigration law. But I didn't think that that's what the majority opinion in Padilla was requiring.
If it's truly clear, criminal defense lawyers now have to educate themselves and become aware of that. If it's not truly clear, then the warnings that we have right now are sufficient. Telling somebody what's going on in the street is not Justice Kennedy, Chief Justice Kennedy. I respectfully disagree with that conclusion. Thank you very much. I ask that you reverse and remand the letter plea again.
Thank you. We thank you both for your arguments. That's the last case today. The court is now adjourned.
All rise.
for watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.